dream I know deep up my feelings for you. Watch.
Hello viewers, welcome back to this channel. Thank you all so much for joining us. The headlines: it is time for reasoning to prevail. Sowore demands release of Nnmadi. But before we proceed with this news, welcome to Reality Latest. This is your home of news and politics. Thank you all so much for joining us on today's news. If this is your first time of watching, please do us a favor to like and subscribe and also share. Don't forget to turn the notification bell to get notified when next we drop our video, because I'm sure you don't want to miss out the trend and latest news happening on social media. To all our amazing subscribers, thank you so much for joining us. To all our viewers, feel relaxed, enjoy and stay connected. The candidate of the African Action Congress (AAC) in the 2019 and 2023 presidential election, Sowore, has restated his call for the release of detained leader of the indigenous people of Biafra (IPOB), Nnamdi Kanu. Sowore made this call in an interview on Arise TV on Thursday. He said the resolution now campaigned and insisted that there would not be peace and progress in Nigeria without justice. So let them use the opportunity to ask for the release of Nnamdi Kanu, because it is time that reasoning prevail over the issue of Nnamdi Kanu. This whole thing was unnecessary. That if you are not, going to continue with Buhari policies of returning the economy, destroying the dollars, don't continue with his repressive, policies. It's time to apologize to all the persons that Buhari touched in the last 8 years of his administration and persecute all the officials used in committing atrocity under his government. You can recall that Nnamdi Kanu has been in detention since June 2021 after the regime of former President Muhammadu Buhari, in collaboration with the Kenyan government, they kidnapped him in Kenya and rendition him to Nigeria in violation of national and international law and treaties. Meanwhile, Sowore said he deserved an apology from the Nigerian government for his arrest and detention in 2019. When asked if he would demand an apology following the discontinuation of his case by the federal government, Sowore simply said he don't have to demand an apology, but he deserves an apology from the Nigerian government as a matter of fact. Recall that Nigeria government had discontinued the case against Sowore over alleged treason. Sowore was arrested and detained by Nigerian Intelligence Agency, the Department of State Services, in August 2019 for calling for a revolution in the country under the then President Muhammadu Buhari's government. He was later released on bail but could not leave the country as part of his bail conditions. But a notice of discontinuance stamped by the Federal High Court in Abuja on Thursday and signed by the Attorney General of the Federation and Minister of Justice Lateef Fagbemi on Wednesday said that the compliant Federal Government of Nigeria would discontinue the case. The notice read by the virtue of the power conferred under him under Section 174(1)(c) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, Section 107(1) of the Administration of Criminal Justice Act 2015, and all other power enabling him on that behalf. Honestly, this man has suffered. The Supreme Court failed to release certified true copy of the judgment on Nnamdi Kanu, the leader of the indigenous people of Biafra. Is a violation of the Nigerian Constitution. The Supreme Court had on December 15, 2023 ordered a continuation of Nnamdi Kanu terrorism trial at the Federal High Court in Abuja, and they have failed to transmit copies of the judgment after more than 33 days. Following the delivery of the said judgment on the 15th December 2023, applications were filed for the release of certified true copies of the judgment and the enroll order, but to this time, the Supreme Court is yet to comply. The lawyer even cited Section 36(7) of the Constitution, which provides that any person being tried for any criminal offense in any Nigerian court is entitled to obtain true copies of judgment on him or her in the case within 7 days of the conclusion of the case. But this failure to release the said certified true copy is a flagrant violation of the Constitution that entitles Nnamdi Kanu to be issued copies of judgment within 7 days of delivery of the judgment on 15 December. So it is a fundamental right and thus is enforceable. The IPOB lawyer said that the Supreme Court failures imply that the Federal High Court cannot proceed with consideration of any trial without the certified copies of the judgment and the enroll order. Nnamdi Kanu lawyers cannot proceed with his defense without the certified true copies of the said judgment and the order. Mr. Nnamdi Kanu was first arrested in 2015 during President Mohamed Buhari administration. The Court of Appeal in Abuja on 13 October 2020 held that the IPOB leader was extraordinary rendition to Nigeria, and that the action was a flagrant violation of the country extradition threats and also a breach of his fundamental rights. The court, therefore struck out the terrorism charge filed against Nnamdi Kanu by the Nigerian government, and they ordered his release from the facility of the State Security Service. But the government refused to release Nnamdi Kanu. Rather, they were insisting that Nnamdi Kanu could be unavailable in subsequent court proceedings if released, and that his release would cause insecurity in the southeast where he comes from. The government, through the Office of the Attorney General of the Federation, later appealed the court's ruling and subsequently obtained an order staying the execution of the court's judgment and the Supreme Court. Delivering judgment on the appeal, the Supreme Court reserved the acquittal granted to Mr. Nnamdi Kanu by the lower court and subsequently ordered a continuation of his trial at the Federal High Court. Is this not wickedness? Moreover, the principle and guidelines on human and people's rights were countering terrorism in Africa. But in the preliminary objection filed by the federal government and the Attorney General of the Federation, they described the suit of Nnamdi Kanu as an abuse of the court process, urging that the court should dismiss its process. The defendant heard that Nnamdi Kanu had filed an earlier suit with similar facts before a federal high court in Umuahia. But at the proceeding, Aloy Ejimako informed the court that he had taken over the case from Mike. The trial judge, Justice Inyang, directed Ejimako to find out if a similar matter was not before a sister court or if a judgment had been delivered in similar suits. The judgment ordered that a hearing note be issued and served on the defendants who were absent at the proceeding. Honestly, it's really time for them to apologize to all the person that President Bola Ahmed Tinubu touched in the last 8 years of his administration and persecuted all the officials he used in committing atrocity under his administration. Honestly, Nnamdi Kanu demand an apology. They've detained that guy so long without anything. He's a freedom fighter. He's not a terrorist. So guys, let me know your thoughts, your contributions, your opinions are in the comment section. We'd love to hear from you. Let's keep the conversation live in our comment section. Once again, thank you all so much for staying to us. Really do appreciate. But if you haven't subscribed to our YouTube page yet, please do us a favor to like and subscribe and also share. Don't forget to turn on the notification bell to get notified when next we drop our video, because I'm sure you don't want to miss out the trend and latest news happening on social media. On this note, we have come to the end of today's segment. Like, comment, awareness, stay safe, guys. Bye.